Hi there, my name is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I want to talk to you about a concept that is, I think, really important when you enter into a Social Security case, and that is that the judge in your case is not going to excuse your lack of understanding about the law. And this is especially true if you're doing this on your own, but even if you have an attorney, you need to make some effort to learn a little bit about the law, because if you don't know what the law requires of you, then for the most part you're going to lose, and don't expect the judge to go out of his or her way to explain it, even though they really are supposed to do that. And kind of what got me thinking about this was that a colleague of mine in Chicago, an attorney named Jonathan Pearson, who I know, I've met him at conferences, nice guy, good attorney, he wrote a very interesting blog post called, "Will Social Security Use My Ignorance for the Law Against Me?" And I'm going to link to that so you can read it. And he talks about a very interesting case where a claimant, I think the gentleman's name was Mr. King, he was denied because he testified that he could not do his past work as a truck driver. Apparently Mr. King had been a truck driver for many, many years. But he didn't discuss in his testimony about his capacity for doing other kind of work. Now this blurb did not say, this blog post didn't say if Mr. King was represented or not. My guess is he was either not represented by an attorney or his attorney was not very experienced. But either way, I think what probably happened here is that Mr. King at his hearing froze, and the judge was asking him questions about what he could do, and the only thing in Mr. King's frame of reference was what he did as a truck driver, the sitting for extended periods of time, the use of the hands for changing gears, the lifting and maybe loading and unloading the truck, that sort of thing. And it probably just wasn't in his frame of reference to think about, well, could I be a food server? Could I be an office clerical worker, a ticket taker at a movie theater? And so he didn't volunteer any of that. And the judge denied his case and basically said, well, all he talked about was the fact he couldn't drive a truck, and I'll accept that, but he didn't say anything at all about not being able to do anything else. So I'm going to assume that he could do other things, and denied the case. Well, Mr. King got an attorney, a good attorney for his appeal, filed the appeal, and the appeals counsel said, Judge, we're going to remand this and send it back to the judge for another hearing, because, Judge, at the hearing level, you needed to make more effort to find out what Mr. King could and could not do outside of being a truck driver. That the judge has some obligation to develop the record. And that's true. The problem is, and any attorney who's done this for a while knows this, judges are really busy, and they don't have time to worry about people who don't understand the law. And for the most part, they're not going to do much to develop the record. And of course, most people don't appeal, and most of the time the judge's decision is not going to be very blatant, very clear that he didn't ask this person about what he could or couldn't do. A lot of times the decisions will say, we talked about these things, or it was implied. So this is kind of a rare case, and it's rare that a case like this would go to appeal and it would be reversed on appeal or remanded on appeal. But the point is most of the time it's not going to happen. So when you go to your hearing, you have to understand the threshold issue in your case, and that is, can you do any kind of work at all? Set aside whether you could do your past work. Let's assume you couldn't. You won't testify about that. But you can't just go in there and say, I can't be a truck driver anymore. I can't be an administrative assistant. I can't be a phlebotomist anymore. I can't be a warehouse worker anymore. We need to know why you can't do those things, but beyond that, we have to go to the next step and say, could I do a simple entry-level warm body kind of job? And I've got to be able to testify why I couldn't do that. And so that's why when I do my pre-hearing conferences, I go through that with my client. If I said to you, here's a job, you're sitting at a table, you're putting ink pens in a box, 8 hours a day, 5 days a week, you'd be bored out of your mind. There's nothing you have to do other than just be there and do this one task over and over and over. You're being paid minimum wage. It's not a fun job, but could you do it 8 hours a day, 5 days a week? Or is there a reason why you couldn't do it? And being bored court is not a good enough reason, by the way. And so you want to be able to testify, that you physically can't sit for more than 7 or 8 minutes, and you've got to walk around for 7 or 8 minutes away from the work site. Your attention and concentration is so impaired by your level of pain, you would not be able to do that job for more than 50 or 60 minutes. So you want to be very, very specific. And this is what an attorney will do in a pre-hearing conference. But realize that that's the threshold issue, is whether you could do any kind of work at all, not just your past work. And you want to prepare for that. You want to have your attorney prepare you for that, and a good attorney will prepare you for that, because that is the main issue. So that's, I think, my takeaway from this very interesting blog post that Jonathan Pearson set out, and that is that the law says the judge is supposed to develop the record and help understand, or really understand more about what you can and cannot do, but realistically it's probably not going to happen. So let me know what you think. Do you understand the difference between not being able to do past work and not being able to do any kind of work at all? If you had a hearing, was that point made clear to you by your lawyer or by the judge? If not, what was your understanding? Were you denied on that basis? And what was your understanding of what you had to prove? I'd like to know that. What was your understanding when you went into your hearing as to what you had to prove? Leave me a comment, and let's have that discussion, because I think that's something that a lot of people get very confused about. Even though I try to make it very clear on the YouTube channel and my website that this is the main issue, I think a lot of people get confused about that, and it's understandable. Again, your frame of reference is what you've done, and to think about what you might be able to do in some job you've never been at is kind of difficult. But let me know what you think about that. And while you're at it, if you thought this video was helpful, give it a thumbs up and like our page, subscribe to our page, and go to my website. It's ssdanswers.com. You can download my Secrets to Winning Disability Survival Kit. If you'd like a case evaluation, if you're not represented and you'd like a case evaluation, you can get one there as well. So hope you found this helpful, and I'll look forward to hearing from you soon. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.